Welcome back to the channel, everybody. Thank you so much for joining me and allowing me to continue to be your daily advocate. If you're new here or you're not subscribed for any reason, please do me a huge favor and hit the subscribe button. Thank you to all of you who have been watching and following me for so long. It truly means a lot, and I'm glad that I can be this person.
The recent increase in the price of XRP indicates that cryptocurrency will have a positive outlook in the coming weeks. Despite the fact that the stock market has had a very low price action, this development has occurred. It will be interesting to observe if this signifies a decoupling of the crypto industry from its traditionally strong ties to other risk assets, as has happened in the past. More information concerning the ongoing litigation between the SEC and Ripple, XRP's parent company, continues to elicit positive reactions from cryptocurrency investors, which is excellent news for XRP. Certain factors allegedly proving that the SEC did not consider XRP to be a security prior to the case have some investors hopeful that the case will be dismissed. However, there is a chance that the price of XRP will fall. It all relies on how Russia responds to the sanctions imposed by the West. The fear is that Russia will not remain silent and will refuse to make any compromises in order to keep control over every region and city in which it has influence. What do you think the cause of the XRP price increase is? We've also noticed another aspect that could influence the price of XRP. As a result, 12 million XRP tokens were transferred from the Bittrex exchange to an unidentified crypto wallet address, according to Whale Alert. It happened during a period when the sixth largest cryptocurrency, XRP, saw a 6.5% price increase according to CoinMarketCap. An anonymous whale has transferred 12 million XRP tokens to an unregistered wallet address, according to a tweet from Whale Alert. This amount of cryptocurrency is almost $10 million in U.S. money. Furthermore, in the Ripple case, in the case of the Securities and Exchange Commission versus Ripple Labs, a new development occurred when the defendant filed a request in court to have the SEC penalized for gamemanship. Guys, this week I came upon a very interesting website. See the link in the description below. It's called Stable Pool, and everyone who registers on their website until October 31st will receive up to $50 in crypto. It's a new platform, but during the first week, they received more than $80 million of investments. They also have a partnership with a Japanese exchange called TaoTaoX.com. When you go to their website, you can immediately claim the free $50. After that, you go to Top Up on the left side of the screen. Then at the right, you select a currency and enter the amount you want to deposit. After that, you are free to go and earn money. Note, I'm not a financial advisor and investing is always at your own risk. So if you're not familiar with the backstory, here's what happened. Dr. Albert Metz, who wrote an opinion on whether Ripple Labs has been influencing the price of the cryptocurrency XRP, recently testified before the SEC. Dr. Metz, a former U.S. Department of Justice officer, came to the conclusion that Ripple's public statements had influenced the price of XRP. Despite the fact that Metz's finding would not be a smoking gun, indicating XRP is a security if accepted in court, it would almost certainly add some supporting evidence to the SEC's case. Ripple, on the other hand, is adamantly opposed. In a tersely written letter, it requests that the Metz report be deleted from the trial. The Securities and Exchange Commission failed to make a required disclosure under Federal Rule of Civil Procedure 26A of the Securities Exchange Act, according to the letter. As a result, the evidence contained within it, according to Ripple, is inadmissible. If Ripple succeeds in this attempt, it will have gained another procedural victory, giving it the leverage to achieve a more advantageous settlement. The Securities and Exchange Commission has been accused of gamesmanship by Ripple. Ripple, on the other hand, has taken a long-standing combative stance against the plaintiffs in the SEC complaint. It accuses them of bias and claims that the entire argument is based on faulty assumptions, which they dispute. Ripple's latest move is a continuation of the company's scathing remarks. A prolongation of the Securities and Exchange Commission petition would reward the regulators for their gamesmanship and further harm defendants, Ripple wrote in a letter to the court. Ripple has used forceful language to indicate that it wants to fight this battle to the end. Will this be beneficial to XRP investors? What are your thoughts? Let us know in the comments section. Ripple Labs is suing the SEC in court, as we've seen. The first question is whether this is of interest to XRP holders. Yes, it is correct. In fact, it has the potential to have a huge impact on the cryptocurrency sector as a whole. Despite their decentralized nature, cryptocurrencies require the help of organizations to function. Ripple Labs is in charge of maintaining the Ripple blockchain, developing RippleNet, and promoting the cryptocurrency XRP. All of these behind-the-scenes actions contribute to the XRP token's increasing demand. When Ripple Labs recruits a company to accept XRP as a payment option, for example, the number of XRP transactions may increase. As a result, there's a chance that demand for the XRP cryptocurrency will rise. It also has the potential to generate favorable PR. In the long run, all of these variables have the ability to raise the price of XRP. If the Commission's case is successful, all of this will be imperiled. Ripple Labs is also being sued by the SEC, which is seeking $1.3 billion in damages plus interest. A significant financial burden of this nature could put a strain on the company, preventing it from focusing on tasks that would help XRP expand. Ripple will be relieved of that liability, as well as the hassle of complying with securities legislation if it wins. As a result, making XRP the best coin it can be will be much easier. The same can be said for the entire Bitcoin business. If the SEC wins the case, it will force the Ethereum Foundation and others to register their tokens as securities under the SEC Act. As a result of this, they would face tremendous financial and administrative burden. Ether investors and others will most likely benefit indirectly if Ripple succeeds. The SEC also filed an application to redact sections of crucial papers, including certain notes from meetings with third parties. The notes are protected under the deliberative process privilege, a common law provision that shields internal agency information, according to the Securities and Exchange Commission. The handwritten portions in question expressly indicate either, first, the author's ideas regarding subjects covered during meetings, and perhaps second, conversations among the Security and Exchange Commission officials during meetings, according to a section of the motion. The SEC is working to redact notes taken by Valerie Szczepanik, the Commission's crypto star, during a February 2014 meeting with Stanford Law School professor Joseph Grunfest and then Commissioner Daniel Gallagher about Bitcoin's legal status. The defendants Ripple, Brad Garlinghouse, and Chris Larson, according to James Villan, filed an application for an extension of time to respond to the SEC's proposed redactions on March 26th, and it was just approved. In addition, the judge has allowed the Ripple motion for additional time with respect to the redacted files, which were presented earlier this month, according to the most current update. James Villan announced the newest news on Twitter. According to the attorney, the court granted a text-only order granting the client's request. The U.S. SEC has been instructed by the judge to make the redacted information available for defendants to study by the 30th of March 2022, and they must react by the 4th of April 2022, according to Villan. The Ripple request for further time regarding the censored documents was granted in a text-only order. James K. Villan tweeted, "By March 30th, 2022, the SEC must submit the redacted documents for defendants' inspection. The deadline for the defendant's response is April 4th, 2022. The SEC recently indicated that if Judge Sarah Netburn upholds her previous judgment mandating the disclosure of the emails, notes, and drafts, the plaintiff will file an appeal with Magistrate Annalisa Torres. The Estabrook notes, which are linked to a meeting between ex-Elad SEC's Roisman and Ripple's Garlinghouse, are the same. Why is the SEC putting in so much effort and dragging this problem out? Because it would bring the XRP lawsuit to a close. According to John Deaton, these records are so important to the SEC that they would rather make a settlement than hand them up to Ripple. It appears Roisman gave Garlinghouse the impression that XRP was not a security. Game over if the Estabrook notes confirm Garlinghouse's evidence and must be produced. The SEC, in my judgment, will not hand over these materials. As a result, if we get an order that they must be turned over, I expect the case will be settled within 60 to 90 days or possibly sooner. John Deaton is confident that if the court rules in favor of providing the emails and notes, a settlement will be reached in 2 to 3 months, if not sooner. Otherwise, the chances of a settlement are 50-50.
So enjoy your day, everybody. I'm always here for you. Leave any comments or questions below, and be sure to subscribe. But thanks, everybody. I really appreciate you. Enjoy your day, and I always have your back. So thanks so much, everybody.